The legal case that's before the leave of appeal before the Supreme Court is a great example of how Concordia uses the law like a gun in the most skullduggerous of ways. In 2001, 2002, Concordia decided to pay full-time faculty who teach part-time courses as extra courses approximately $1,000 more for every 3-credit course. The university had no right to determine what the prevailing part-time faculty rate is for others who teach at Concordia. There's no internal equity. And I'm proud of the fact that as an association, we tend to be cautious and conservative, and we like to consult with our members. And our members, in asking them, should we contest this and to what level we should contest this, gave us the mandate and the authority to do whatever was necessary to obtain equity in terms of our salaries. Well, we go to grievance. Not surprisingly, we lost. Grievances are handled internally. From there, we went to arbitration, and we were absolutely delighted to discover that we won the arbitration. What did Concordia do with this? Did they pay us the close to $1,000 for every 3-credit course? No. They decided to go to leave on appeal judicial review. Judicial review must be argued before the Supreme Court of Quebec, the Superior Court of Quebec, on technical grounds, not on the merits of the case. By some bizarre reason, the judge, erroneously in that case, decided to decide in favor of Concordia in terms of some technical thing that the arbitrator had done. Again, in consulting with the membership, we went and asked for leave of appeal to the Quebec Court of Appeal. We not only win the right to appeal, but we also appeared before the Quebec Court of Appeal, where a unanimous decision by 3 judges agreed that Concordia had no right to have an inequity of salaries internally vis-a-vis all part-time contracts. What has Concordia done with this decision? Did they pay us the something odd $1,000 that we have a right to, in which a unanimous decision has been given? No. They have decided to ask for leave of appeal to the Supreme Court of Canada. Imagine. What does this mean? It means, and I think this has to be very, very clear in terms of the waste of public funds, that when you get a decision based on salary, the interest is compounded daily. So what started out as a global amount of maybe $6 or $7 million to this day has now worked out into a figure of $13 million that they owe part-time faculty. Now, it's unlikely that they will win such a decision. So it begs the question, why are they wasting public funds? Why are they continue to declare war and make declarations of war? Why are they avoiding, the issues of equity and equality? I ask, how can we possibly have confidence in the negotiations of a new collective agreement when they're not prepared to honor our current collective agreement, when they're not even prepared to honor the decisions made by the Quebec Court of Appeal? How can one continue to have confidence in an employer who treats its part-time faculty in this manner?